Hello, this is Matt on the Moon Family Sedan channel. Several days ago, attorney Jeremy Hogan shared what he believes is the number one reason that XRP is not a security. And he went into great detail in a thread on Twitter, and all sorts of crypto media outlets cover the story, including this headline from Cointelegraph. Lawyer lays out his reasoning on why XRP is not a security. And I covered his rationale in great detail. It was very interesting, very thought-provoking. Not going to go through all of it again, but just to set the table to make sure that you know, in a general sense, what was discussed. It was this idea of basically Ripple's primary argument when it comes to their summary judgment assertions, what's being considered by Judge Torres in this case, that XRP, there can't be a violation if. And it can't be an investment contract if there's no investment and there's no contract. But although you've probably heard that argument at this point, if you've been paying attention pretty closely, attorney Jeremy Hogan added notable and very interesting nuance. But again, I don't want to rehash that because I went into great detail in covering his very thoughtful explanation of why that is. But he's added to his thoughts. So he put out some new thoughts. He wrote, number 2 reason why Ripple did not sell XRP as a security just about 15 hours ago. So this is the latest from him. And I want to share with you exactly what he had to say. And the more you go through this, the more it just, there are also hints. And this is part of what he was kind of noting here. And I'm wording it like this isn't how he worded it. I'll share with you his exact words because I never want to put words in anyone's mouth. But it looks like he's kind of highlighting the way in which Judge Torres may be approaching this case just in general. And so to some degree, it looks to me like it's providing a hint that she may not be thinking in favor of the SEC. So we'll go ahead and break it all down. But before going further, I do want to be clear. I do not have a legal or financial background of any kind. I am not offering legal or financial advice. And you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. All right, so latest from attorney Jeremy Hogan. He wrote the following. The number 2 reason Ripple did not sell XRP as a security. The recent opinion from Judge Torres provides a clue as to how she might, rightly, find that XRP was not sold as a security. First, look at the version of the Howey test she cites. And then it's right here, the relevant portion is towards the bottom. I don't feel the need to read the whole thing, but this is the screen grab that attorney Hogan shared. And it's the part towards the end here with profits that come solely from the efforts of others. And so in the following tweet, he wrote, the judge states that prong number 3 of the test is that the purchasers must have sought profits solely from the efforts of others. That was the original test, although decisions since have softened that requirement and basically removed solely from the test. Still interesting. Yeah, so I'll pause to state, I've been aware of that for some time, and that word solely being up there, it's been brought up by attorney John Deaton and others. And it's fascinating, especially for someone like me who doesn't have any sort of legal background, to learn more about the way this, the legal system works and the entire judicial process, so on and so forth. It's just fascinating to see how judges come to conclusions over time, and then other judges look at those opinions. And then I understood the concept of precedent, but it's still just interesting to see that, what might be otherwise considered key portions of decisions just removed because of a decision of perhaps even one judge. And then that's just the case moving forward because precedent is set. So when you're talking about the word solely, well, if that's supposed to be considered or not considered, the implications of just that one word are absolutely gigantic. Solely from the efforts of others versus on the efforts of many other entities? Well, when it comes to XRP, think about that. Are we relying solely on the efforts of Ripple or on the efforts of a thriving XRP ecosystem? So obviously, even just that one word would have a tremendous impact. But see, that's why attorney Hogan is pointing out here that she cited that, the old-timey version of the test, that includes the word solely. She didn't have to use that version. That's what she put in there. That's the hint. And then attorney Hogan says, As evidence that XRP purchasers were relying on the efforts of Ripple, the SEC retained an expert witness to provide an opinion. And, no surprise, he stated what he was hired to say. But the judge specifically struck that part of his testimony in her recent order. And that part reads as follows. So this is from Judge Torres, and this is at the beginning part of March. You may recall this is when she came to her conclusion regarding all the Daubert motions, just having to do with the expert witnesses. Would the expert testimony from Ripple side or the SEC side, would it be allowed to be considered in this case? And it was across the board, a major victory for Ripple. So I was happy to report on that back when that happened at the beginning part of March. But here's the relevant portion that attorney Jeremy Hogan shared. It reads as follows. And this is written by Judge Torres here. Expert number 1 lists 6 factors that would have been important to a reasonable purchaser of XRP and analyzes Ripple's public statements using those factors. But he provides no justification for the importance of those 6 factors besides his experience as an investor in digital assets, as well as his close observation of the digital asset space. Expert number 1 does not explain how his personal experience as an investor is a sufficient basis for his expert opinion about how others decide whether to purchase XRP. He does not cite any sources supporting his method of measuring the perceptions of XRP purchasers or their behavior. And at his deposition, expert number 1 conceded that he did not speak to any purchasers of XRP in preparing his report. Without more, quote, generic appeals to an expert's experience are no substitute for reliable principles, and then it kind of cuts off, but you get the point there. And so that's like, that's a pretty firm decision right there. It really just completely tears apart. You know who they're talking about there. That would be Patrick Doody. That's expert number 1. Doody. His last name is Doody. Can you imagine being in high school and your last name's Doody? That could not have gone well. That absolutely could not have gone well. You got a feel for the guy, right? But so he basically just said the assertion was, here's my perspective, my personal opinion, gave no sort of method, any reasonable way of measuring this. He just made the assertion and then on top of that, never spoke with any XRP purchasers. Found that out at deposition. So that's thrown out. Judge threw that. It's like, she's like, well, hell no, that don't make no damn sense. I bet that's Barrage. And then attorney Hogan says, this leaves the SEC expert witness number 3 as the sole expert to testify about the third prong of the test. Expert number 3 testifies, in short, that Ripple manipulated the price of XRP. But the question asked by the test is what XRP purchasers thought or knew when they were buying XRP. So I'll just pause to ask, did you know that whether or not Ripple attempted to manipulate XRP, that's not the test? It's whether or not XRP purchasers thought or knew that Ripple was attempting to do such. So even if Ripple was trying to do that, if XRP purchasers weren't aware of that, then it doesn't matter, even if Ripple was trying to do that. Now, so that's a much higher bar. You can see how difficult this is. I love Attorney Hogan's nuanced approach to all this stuff. It really breaks it down. Anyway, and then Attorney Hogan says, and nowhere does expert number 3 state that XRP purchasers knew anything about price manipulation. In fact, the expert states that what Ripple was doing was being done in secret so people wouldn't know. So folks, think about that. The expert states something that strengthens Ripple's case. Oops. And then Hogan says, without connecting Ripple's actions to behavior, the testimony fails as proof, which leaves the SEC with a cacophony of various statements made by Ripple as its evidence of the number 3 prong. These include marketing materials, tweets, and statements that an increase in XRP's price was Ripple mania. I just envisioned a wild and wacky arm-flailing inflatable tube man when I read Ripple mania. Did you? And then Attorney Hogan says, and the evidence that XRP buyers saw these things? Nada. So again, all these assertions, Ripple was trying to do it. But where's the proof that XRP holders were aware of any of this? Doesn't exist. And then Attorney Hogan says Ripple, on the other hand, has witnesses that testify XRP was publicly deemed a currency and an asset, not a security. Yes, the SEC found 6 XRP holders involved in a class action to say otherwise, but Ripple has thousands of XRP holders to counter those statements. Finally, the SEC's own expert admitted that most XRP price movement since 2018 has no relation to anything Ripple does. For those reasons, the overwhelming majority of the evidence is that XRP purchasers did not rely on the efforts of Ripple. No reasonable juror could possibly view the paucity of evidence presented by the SEC and come to the conclusion that the SEC met its burden of proving prong number 3 of the Howey test. Therefore, Ripple should win. Second reason. Thanks for reading, especially you awesome law clerk. Yeah, so I do hope that the law clerk does happen to be following what Attorney Hogan is saying, just for a little bit of help, a little bit of free help right there. It could be awesome if that kind of went up the chain, because Attorney Hogan is correct. Absolutely. And then there's one extra little piece here. Somebody named Seth Money wrote to Attorney Hogan in response to that and said, does the judge make the decision on her own, or does she have a small circle of people, maybe other judges or clerks or personnel that she consults with, informing her decision? And Attorney Hogan says, most federal judges have a law clerk or 2, young attorneys that help. So she is consulting with others, using other brain power from other humans to come to the conclusion, but the call obviously ultimately is entirely hers. But she's informed. There are all sorts of hints that lean towards, favoring XRP holders, even if not explicitly Ripple. And I'm excited to see how this goes. I'm very optimistic. Don't disappoint us, Judge Torres. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Family Sedan.